Good morning and welcome to the Morning Scoop for Friday, April 2nd. This is your daily Buckeye Fix. I'm Tom Orr. The Minnesota game is in 163 days, the game against Michigan in 239 days. This was potentially a monumental week for the future of college sports as the Alston case went before the Supreme Court for arguments. Dan Lust, an attorney specializing in sports law and the co-host of the Conduct Detrimental podcast, is my guest this morning. Dan, we talked about this case a couple months ago, but can you give people just sort of a brief reminder about what the Alston case is all about?
Sure. So we could do it at a high level. I guess there's two questions, right? It's like, what is this case about? And then what does the case represent, which is the larger picture issue. But this case is a pretty minutia. And I think last time I was on Explained, I thought it was kind of odd that the Supreme Court took the case in the first place. Sean Alston is a West Virginia running back. He's suing with another football player, and they're essentially alleging the caps that you could put on, reimbursements. And it's a very, we can get into specifics, but it's basically you could get reimbursements on laptops, books. They were capped at whatever they can get in reimbursements, and also what they were allowed to do for outside work, be it summer externships. All that had to run through an NCAA because of fear of potential booster involvement. So it's not full name, image, and likeness. It's basically just the argument we've heard, like, why are athletes and athletes alone given these restrictions? So they're trying to chip away at amateurism. It's not full name, image, and likeness on that was in front of the court, but a very minute issue. So how we got here, they went to the Northern District of California, which is where once upon a time Ed O'Bannon won his lawsuit against EA Sports and all these other guys. He went to that court from a West Virginia running back, went all the way to California because he knew that he'd get good case precedent there. Alston won at the lower court level, and he won at the Ninth Circuit Court of Appeals. That's the second level of courts. And then, I think to the surprise of many, the Supreme Court decided to take this case, which is seemingly a smaller case from a historical precedent than other ones that could have gone up. But, I'm not arguing. Sports law in the Supreme Court is definitely a good day.
So, if this is just about kind of a smaller piece of this and not directly about a name, image, and likeness, how do those two things fit together? If this case is found in favor of Alston, would that then make it more likely, or would it make it harder for the NCAA to defend the image, their opposition name, image, and likeness? How do those two pieces kind of fit together?
So put it this way, and there's a lot of misinformation out there. So put it this way. Let's say that there was the structure of paying college athletes, right? And you needed to pay needed these different fundamental structures. Now, one lane of the structure, let's say there's the legislative lane. You need, legislation behind you to get name, image, and likeness done. And I'm going to call legislation, be it state, federal, or I'm going to say the NCAA's version of legislation, passing their own name, image, and likeness laws. Now, those are really, called the Constitution, collective bargaining agreement, all these fun contracts underneath sports. You need something here to, basically create a playbook of how it's going to happen. So that's name, image, and likeness on the table, and that we're going to call it making rules, right? Legislation, whatever you want to call it. Now, this is an issue in the judicial branch. I'm going to call it a separate column that's holding up this house. It doesn't really, and this is maybe where the misconception lies. If Alston wins, fantastic. It's another chipping away at amateurism. But amateurism is not, the full conversation is over in that separate column next to it. That's what's not a debate. If Alston loses, great. We go back to a world where athletes can't get reimbursed for laptops. It's not life-changing. It's not really going to matter that much. I'm sure, nobody really knew the rule ahead of time that wasn't following it that closely. Now, it's kind of likewise, and I don't know if anyone's aware of this, but the NCAA, with the position they've taken, and I can explain it, but they're not taking a be-all, end-all type position. If the Alston wins, great, you get reimbursements on laptop. NCAA wins, great, you don't get them on laptops or and books and whatever else. The NCAA, what they could have done is asked for what Major League Baseball asked years ago for an antitrust exemption, and I think the last time I was on the podcast with you, I thought that's where they were going to go. But their final briefs didn't ask for that. They were very clear that we're not asking for an antitrust exemption. We are arguing that what we do does not violate antitrust law. So you'd ask for an antitrust exemption if you're going to say, hey, we're clearly violating the laws that are in this country, but we think we should get an exception for doing it. So had they asked for an exception, that would have created a whole sort of chaos, because the NCAA got an antitrust exemption. They don't really have to do anything. They can keep these draconian laws on the books and treat their athletes however the way they want, because they can't get hit with antitrust liability. So the O'Bannon case, this case, the Alston case, they all have antitrust tones, and all the way going back to the Board of Regents case in the early 80s, which created the college football television network as we know it. all antitrust cases. And if you remove antitrust protection, you can do really whatever you want. You're not going to get hit with these lawsuits. So yeah, they didn't ask for it. So it's kind of like, there was maybe a giant bomb that could have exploded one way or the other. And, there's nothing really that's so monumental at stake. But, at least the part I do want to point out, maybe not everyone knows this, and it's a fun conversation, Tom. We should, I think I'm happy to educate people. But the U.S. Solicitor General entered the conversation here, and it's Elizabeth Preligar, and asked for permission to give oral argument on behalf of one of the parties. And maybe if you're thinking federal government, they're going to support the NCAA because they support a lot of states. Not true. She went and ended up supporting Sean Alston. She gave oral argument on behalf of the players. So everyone was kind of thrown off by that. It's not a normal move from the Solicitor General. But there are all these fun conversations occurring at the federal legislative level. So maybe that was a wink and a nod, like, hey, we're kind of a federal player. We're kind of getting involved in this, and it's a sign of things to come.
Yeah, I mean, that was one of the things that seemed like there was just a bunch during the course of the day as you're hearing the questions the judges are asking of the NCAA. It was like, this just doesn't seem like it's going the NCAA's way. And that started very early in the day when the NCAA's attorney identified the wrong justice as the chief justice. That's a little whoopsie. But then, just you listen to the questions that the judges are asking. And, I know if you followed Supreme Court cases in the past, like you can get yourself in trouble reading too much into that. But, based on the questions you were hearing, what did you think were like the biggest potential points of vulnerability for the NCAA based on those questions?
I mean, the biggest vulnerability for the NCAA, honestly, it's kind of optics. And Judge Gorsuch pointed this out, and I was having a lot of fun with it on Twitter. But essentially said college football is a sport of billions of dollars. And this case comes down to a couple $1,000s, right? Reimbursements for laptops, books. How much money could that really be? So he said, why are you making it seem like $6,000 is a lot of money? You guys make billions, and you sit, and I'm hyperbolizing, but you guys sit on a gold stack of, a stack of gold. You're sitting high and mighty. Why are you arguing over these little pennies at the bottom? So it's the optics. I think it does from a competitive standpoint. If you're going to say, like, we're not going to make our schools compete from anything from, like, let's say hypothetically, right? The Ohio State University, who I think this podcast is probably partial towards, they had more favorable restrictions, we'll say, or less restrictions, probably the easy way to put it. And they said you could get reimbursements on your books and your laptops and all that stuff. Maybe that would convince somebody to go to Ohio State over Michigan, right? Now, that's like a very minute example, but like, let's say you said, okay, Ohio State can pay their players and Michigan can't. So, you're going to win that recruiting edge. So the bench kept hitting the NCAA that, like, this looks like a restriction of trade. This looks like a restriction of competition. You're not forcing the schools to compete against them because you have these archaic rules in place. So, I think the other thing that probably hurts the NCAA, I don't really know what side I feel truthfully on, but this whole concept of amateurism, like, pros and amateur athletes it's a pretty gray area at this point. Like, I think it was very clear when athletes were staying 4 years at school and they were getting an education. But it's a little different now. Guys are setting themselves up to play in the pros. So it's a feeder system at a certain point. It very much feels like that. And with access to athletes and social media, it's a different world for athletes. So NCAA wants to protect this thing, amateurism. And maybe the part that hurts the NCAA, I could make that point, is that amateurism doesn't really exist anymore. So why are we fighting to protect something that's just kind of a farce in the world that we live in?
There was one area that I thought it seemed like things went maybe better for the NCAA, or you sort of started seeing questions from some of the judges asking, something that maybe sort of pushed back a little bit on the Alston side, which was more or less, what makes, us as an entity or judges somewhere better suited to make decisions on how to run an organization and set the rules for an organization than the NCAA would be itself. So, if that ends up being a sticking point for the majority of justices, could that alone swing the case on this, like, sort of, I don't know if it's a procedural issue, but, could that alone swing the case? How big of a difference could that make? Or is that just, probably not going to be a big enough deal to swing the result here?
Here's the tricky part. I'll give you my stream of consciousness here, because the truth is, like, they spent an abnormal amount of time. I don't want to say abnormal. A large portion of the arguments just bashing the NCAA, bashing them over the head from all angles. So if you were watching and you didn't know what to expect, it's not really that normal that they spend very clearly a larger percentage of time bashing one side. Now, and I think part of that was political. They want to look like they're protecting athletes, and judges aren't crazy. They feel the public sentiment. So that was part of it. Now, if you were kind of coming to it anew, you'd be like, okay, obviously the judges are going to go rule against the NCAA because they're attacking them and they're being really mean to them and they're making the lawyer look bad and they're laughing when he gets the Chief Justice wrong. Like, it was a hostile environment. Let's just say that the NCAA did not feel like they had home field advantage during this hearing. It was very hostile. But there have been times, and people that follow the Supreme Court. I Tom, fully admit, I follow sports cases in the Supreme Court. Otherwise, I'm not following SCOTUS blog and all these other cases. But you read enough people, and they say that there are times when the justices will pick on a position and they will go after them, they will bully them, and they'll actually rule in favor of them because they're trying to just figure out the where they can give them an out, right? They're asking really hard questions. If the lawyer responds properly, maybe they'll fashion their decision in a way. So I don't really think the lawyer handled the questions that well. I don't think he said anything that was so monumental or different but there have been times where people have unanimously said, okay, we're going to get a 9-0 verdict, we're going to win, and then it goes out the other way, or it's 5-4, 6-3. But yeah, I don't. If you're betting, you want to say that that's not normally going to happen. But here, I basically don't bet the house on it yet. Let's say it's like minus 200. But if you got upset at this point, it's possible.
So, boy, you're really speaking everyone's language now. But if everyone could just speak about Supreme Court cases in terms of gambling lines, the world would be so much a more clear place. I guess the question is, I guess there's sort of a spectrum of outcomes here potentially where they could they find is there like a wide variety of outcomes, or is it just kind of going to be yes or no, or could it be yes, but, or a no, if? Like what is the kind of spectrum of outcomes we could be looking at here?
They could do a couple things. They could affirm it and then, change, or affirm it in part, deny it in part, and they could send it back down for different issues. And we'll get in the weeds, but the truth is this: short of the judges going a complete wild card and deciding something that wasn't in their motions, and that's that antitrust exemption, I don't see that happening. But I'm just calling it like I see it. I told you I was on with you last time. Alston won at the lower court level, and he won at the second and the Ninth Circuit Court of Appeals. That's the intermediate level. Sometimes I don't want to say it doesn't happen. Sometimes the Supreme Court hears an oral argument because they think it's an important issue, and they affirm it. But it just seems odd that they would have this old, dog and pony show, bring them up to Supreme Court. They have 90 minutes of oral argument and all these different press, and it's a very big day. I mean, sports obviously brings a lot of firepower to it. And they just said, hey, we're going to affirm what we said before, and Alston's right again. It would seem odd that was what they're doing. Maybe they want to write a sweeping opinion, and maybe, and this is also possible, there hasn't been any college sports law that come from the Supreme Court in 40 years. So maybe glass half full guy over here, maybe they're taking the case to say, you know what? We want to write an opinion that's going to be very clear and it's going to give everybody guidance on how to act. And it's going to set precedent for the next 40 years. Maybe they thought it was important enough to just address. And they're going to write a beautiful opinion, and they're going to scathing opinion against the NCAA. And they're going to affirm it. The result's going to be boring, but the language could be very good for the future of college sports. I don't think it's a coincidence, and this is probably why they took the case. This is me, and I know the Supreme Court justices aren't supposed to think like this, but I have to think it does matter. Governor Newsom over in California got a lot of good publicity from taking on the legislation of paying college athletes. He signs the bill very fancy on LeBron's show on HBO. This is an issue that has the ability to change college sports as we know it. And I think all these justices probably want to address that issue head on. And I'm sure listening to Justice Thomas talk about Ohio State, and he's talking about Alabama and Nebraska, I'm sure they're having a lot of fun talking about this case. So yeah, there's a lot of ranges of outcome, but I think why they took it is to write a scholarly, beautiful opinion to help direct the focus of college sports for years. Because, between now and July 1st, the waters are going to get very muddy on what you can and you can't do, what certain states like Florida and maybe Oregon can do and other states can't. So There's reports that this decision could come out by June. Give you a little bit of time. That's a month before Florida's supposed to go into effect. So, yeah, but I don't know, you and I can get into it, Tom, but like, no matter how the opinion shakes out, we're still going to have a nightmare on the name, image, and likeness legislative level, short of some federal bill or something coming down.
Yeah, that was my next question. Was you've got the court potentially ruling for the plaintiff sometime in June, for example, and then the NIL bill in Florida set to go into effect on July 1st. What kind of recourse does the NCAA have at that point? Is there anything they could do to slow down or stop that, or is it just like, if they've lost Alston and then the bill goes into effect, it's like game over? I mean, what does the NCAA have as a possible fallback if all this stuff starts to kind of all these wheels are in motion?
So, I can tell you what I think they could do, what they might do. I don't know if they're going to do it, and I don't know if they do it, it'll be successful. But there's something in our world called an injunction. An injunction is basically like, how do I phrase it? It's like you could put the screeching halt on a train that's going 100 miles an hour. An injunction is an emergency order to stop something from occurring in its tracks. And I use the train analogy on purpose, but name, image, and likeness is plowing through full steam ahead. And if they file an injunction, you can get it from a court. And I'll explain who the parties would be here. You could get an injunction to stop something that would be the word is irreparable harm. So if you have unrepairable harm, that something could happen, the court might step in and intervene. So who would the NCAA be filing an injunction against? Where? Now, right now, the only state that has name, image, and likeness that's going to effect on July 1st is Florida. There's a couple other ones that have supposed to have triggering dates in the months that follow. But there's, I don't want to say there's a world. I mean, it's going to happen. July 1st, Florida doesn't have to listen to the NCAA. Even if the NCAA passes name, image, and likeness, Florida's state law. So NCAA can't tell Florida not to abide by state law if they have to allow college athletes to get paid in the way that the Florida legislature envisioned. They're not going to go with the NCAA watered down version, or else they violate state law. So, Florida's version is going to be better than the NCAA's version. I can promise you that. Just not going to be a secret. But the irreparable harm that could result, you can imagine if there's a recruiting edge, it's going to happen for Florida, Florida State, South Florida, UCF, Florida Gulf Coast. One-time March Madness appearance guys. I think they were like five slamma jamma.
Dunk City, right?
Dunk City. I knew it was something like that. But yeah, so that's irreparable harm. I could see it. And I'm seeing smart guys like Dennis Dodd. I'm seeing it in ESPN, and I'm seeing people talking about there being an injunction filed by the NCAA against maybe either the state of Florida or the Florida schools to avoid these name, image, and likeness laws from coming into effect there. And then they would have to seemingly take that same course with any other subsequent state. And what are they asking for? They're going to say, well, the federal bill is coming. It's coming soon, we hope. And we'd like you to stop these while the federal bill can come. And they'd have to show that this injunction is not going to last for perpetuity, that there's going to be some logical end frame to time frame. But no one's really going to know that because the wheels of justice, the wheels of the legislature move very, very slowly. We had Tom, we had on my podcast 2 legislators that had passed sports betting bills. And, I speak the lingo. I love for sports betting to be legal in every state. Maybe there could be a federal bill at some point. Short of a federal bill, all these states, they're going to, they want to get their name attached to these bills. And what's happening, because again, what you see with Governor Newsom over in California, people are like, hey, and they're like you and I, right? They're Republicans, they're Democrats, they have bipartisan bills, and they're like, I want to make a sports betting bill. I don't want to, care about, whatever education, that stuff I'm sure they care about, but it's like, I want to do a sports betting bill. That's fun. So you're getting not just 1, not just 2, not just 3, like 10 sports betting bills, 10 name, image, and likeness bills. And it's a fight over whose bill is going to pass. They all have subtle nuances. And then the legislature doesn't want to deal with them because they're all yelling at each other. And they're like, okay, let's put something else to the top of the ballot. We can pass some type of law so we don't look like we're fully incompetent. We're not passing anything. We'll pass something. And sports betting bills and same name, image, and likeness, they're getting forced, in some instances, to the bottom of the barrel. And that's kind of why, I thought the U.S. Solicitor General intervened. She's saying, hey, this is a really important issue. I'm intervening in this case on behalf of Alston. We got to get this thing figured out. But yeah, short of the federal government coming up with their own name, image, and likeness bill, the federal government, and one to be agreed on, there's no easy exit strategy. NCAA's got to file injunctions. Florida might get a recruiting edge, and that would be felt for years. If Florida ended up with the number one, recruiting class in every sport, like that's going to impact college sports for years. And there's no end ifs or buts about it. And I remember when California passed fair pay to play, I believe Ohio State's athletic director, as well as Wisconsin's, both said, like, we're not going to schedule games against California schools. So here's the other part of the coin when I'm telling you it might not be successful. Okay. This is the fun part. If there was an injunction filed against Florida schools, right, and they said, we don't want you to abide by, Florida law. You can't do it and blah, blah, this is emergency. What Florida could do, right, the NCAA is on really shaky ground because people hate the NCAA right now. Like Mark Emmert has a very low approval rating. What Florida, California, whatever schools have name, image, and likeness, and they're going to hit with this injunction, what they could easily say is what happened back in the 80s with the College Football Association. We're going to do our own thing. We don't need you, NCAA, because we're the schools. We have all the power. And that's kind of what happened when you and I think we first met during the Big Ten saga. It's like, Nebraska's going to go do what they want. Ohio State can go do what they want. Like they're not bound by the Big Ten. They can do whatever they want. They could go form their own conference. They could go form their own football entity. So that's the shaky ground that the NCAA is on, because they're basically saying, hey, if you want to play under our roof, you have to abide by our rules, and we're going to hit you with an injunction. And they'd have to, you have the risk that Florida schools would be like, okay, NCAA, sounds good. In order to play under your roof, we have to abide by your rules. Sounds good. We're going to go build a new house over here, and you just found your only competitor that you've ever had in 100 years. So slippery slope, but in the sports law world, super exciting. I mean, fireworks on both sides.
Yeah, this is definitely something that we will obviously be following quite a bit, and it sounds like we'll probably get a big burst of news in June and July, which is great because that's typically not a super busy time in the college football world. So I'm going to guess this is not the last we'll hear from Dan Loss this year. But Dan, greatly appreciate you taking time. I know you have been super busy this week. I popped in on a little bit of you lecturing to was it William and Mary yesterday? Like you have been a busy man this week. So appreciate you taking some time to fill us in on the latest developments with all this.
Yes, I had the Big Ten network, Big Ten Sirius XM this morning. UPenn. I'm now an Ivy League lecturer, Tom.
Oh man, big time.
They don't know I'm a sports betting degenerate, or else I would not have gotten. It's a very fun time for sports law. So yeah, if UPenn is calling me, they're digging the bottom of the barrel to get me over here.
Well, glad you could take some time from the upper crust to mingle with us down here at a football site for a public university. So greatly appreciate it. Thank you, Dan.
Thanks, Tom. Absolute pleasure.
And make sure you check out BuckeyesCoop.com later on this morning. Tony Gerdeman will be at Ohio State's practice to cover it for us. It is our first chance to see the team in person since the national championship game. That's a pretty big deal. There is a lot that he's going to be looking for, providing updates on. We just dropped an episode of the Buckeye Weekly podcast on Thursday talking about the defensive backfield, but we may end up even doing an emergency podcast today, depending on how much we get to see and all that, to let Tony share what he's learned at practice today. Nevada. Oh man, Nevada just had a fantastic update yesterday as well. Insider report from practice on some of the young players who really jumped out this spring. I'm just not going to spoil anything. I'm just going to tell you the race for the starting linebacker spots may be much more wide open than you might have thought. So you can find Nevada's reporting and Tony's work and all of the other great insiders at BuckeyesCoop.com. Consider becoming a member today. You get access to that whole fantastic team of insiders, our Ask the Insiders board. That is a tremendous community, very active community, lots of fun people, lots of great conversations. That is all at BuckeyesCoop.com. It is the price of a lousy chain store pizza, and you get all of that. And if you sign up right now, you're going to get all the spring ball, spring practice, some of the fallout from the end of spring practice, and the transfer portals comings and goings, and all of that. It is going to be a very lively and active year. And once we get through all of that, like, there could be major changes. You just heard it. There could be major changes on the way for the NCAA and college sports in general. We'll have it all covered at BuckeyesCoop.com. And also make sure you check out all of our great podcasts. We have a ton of podcasts. Just added a new one with Dominique Smith. He just dropped the second episode of his show. You can find that all on Apple Podcasts, Google Podcasts, SoundCloud, Spreaker, Spotify, you name it. It's there. Just search Buckeye Scoop. You'll find all of our great shows. Gives in the Bank, Around the Oval, All of them. There is a ton to love about all of that. All those podcasts, of course, free, as is our YouTube channel, youtube.com/Buckeye Scoop. You can subscribe right there. Every time we interview a player, every time we interview a coach, every time Tony will have video from practice this morning. It is all at youtube.com/Buckeye Scoop. All you have to do is go there and hit subscribe, and then you'll get notified every time we drop a new video. So that is going to be well worth your time. Take 2 seconds to do that right now, and then you'll get notified when Tony drops that practice video a little later on this morning. Your first real look inside Ohio State spring football this year. That'll do it for today. In fact, that'll do it for this week. Hope you guys had a great week, and we will talk to you on Monday.